just been a Supreme Court ruling. And look, this is this is not terribly sexy stuff. And I don't know that we have covered it specifically on this program. I think we mentioned this case a while back. And certainly we've talked about it on Ring of Fire Radio because we tend to deal with even more legal stuff, particularly when it comes to class action lawsuits. I don't think this is terribly complicated, but there were 3 cases that were in front of the Supreme Court, and in a 5-4 ruling, the Republicans on the court, and I'll tell you what's interesting, Sue, to me, is just, you see more of the reference of Republicans as opposed to conservatives on the Supreme Court. But nevertheless, the 5 conservative justices sided with businesses who have employment contracts which include mandatory arbitration clauses that prevent class action lawsuits. So, let's say there are 4 or 5 people, or 10 people, or 50 people, or maybe hundreds of people who work for a major corporation, maybe even conceivably thousands, who work for a major corporation that has been systemically discriminating against women and has been underpaying them, let's just say. Or there's been ongoing sexual harassment or culture of sexual harassment there. Or there's been ongoing breaches of the contract over a class of people, a group of people who work for the company. There's all sorts of circumstances where you could get involved in a class action lawsuit against a major corporation as a worker. However, in this instance, these mandatory arbitration clauses, they both inhibit the ability of an individual to join a class, and in many instances, prohibit their ability to go to court at all. Now, understand that arbitration in and of itself is not necessarily a bad thing, but you want a situation where both parties agree to arbitration, entering into that agreement with a fairly equal power dynamic so that they can both make a clear-headed decision to go to arbitration. And often, the best time to go to arbitration is when there is a conflict, not beforehand. And in this instance, when you're applying for a job, you're certainly not going to enter in there and have the legal savvy to know, well, down the road, I might have a problem here that I don't want to be inhibited by an arbitration. And also, keep this in mind. The arbiters are hired by the company. Individuals don't have that much use for arbiters over the course of their life that they would be a longtime client for an arbitration agency. However, if you're a major corporation and you have thousands of employees, even hundreds of employees, over the years, you're going to be a client of an arbitration agency. And that is why all the data suggests that when workers enter into an arbitration hearing, they are far more likely to lose than employers are. This is just one more element that we have seen of the Supreme Court basically barring citizens from getting redress in a court. And these arbitration clauses we saw this in regards to AT&T. I think the case was called AT&T versus Concepcion in California. AT&T was overcharging hundreds of thousands of customers by $3 per month. Now, as an individual, you're not going to bring that case. No lawyer is going to take that case. Maybe you've been overcharged $30, $50, whatever it is. But we're talking millions of dollars in the pocket of AT&T. And unless these consumers in this instance, it's not necessarily an arbitration type of situation, it's just they are not allowed to form a class action. And there's really no way to inhibit AT&T from doing that.
Did the decision cite Jordan Peterson?
It did not cite Jordan Peterson.
Just curious.
No, it did not. But it's
not the collective that's been defrauded. Each individual.
Effectively, the point is just to basically disempower individuals from getting redress, because there are economic realities to this. And not only does this prevent individuals from getting any type of real redress, but it also destroys the incentives for investigating violations of labor law. So much of the actions taken by government regulatory agencies, particularly in environments like these, are built upon information that is dug up by trial lawyers. You can go back and read about the last big settlement that Eric Schneiderman was a part of in the mortgage scam, essentially. The vast majority of investigative work that was done in that government instituted penalty was from private tort lawyers, plaintiff attorneys, who were representing their specific clients. Usually like maybe a big, municipal pension fund or something like that. And so this is just one more way that the individuals are disempowered by not having the ability to form a collective, right? Like, if you want to empower individuals, you have to give them the right to form a collective. You can't,
Marxism.
you're disempowering the individual
communism.
by not allowing them to band together, because we allow corporations to exist.
As people.
And in fact, next Monday, the interview that we've recorded is with a guy, Adam Winkler, who is a law professor who has written about the development of corporations in that respect. So,
as agents of order to restrain the chaos of individual consumers who are feminine.
I was going to say the chaos that is feminine.
The
Period.
chaos that is feminine.
The chaos that is feminine.